Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everybody. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Singh. To my left, Justice Hershfang. We will be hearing one case this morning. The rules are as they always are, and I know you're both familiar with them. 15 minutes per side and no rebuttal. We've read your briefs and are familiar with the facts, so if you want to get right into the argument, that'd be great, although it is your time and you may do with it as you wish. The case we will be hearing this morning is number 22-694, John Doe number 383730 versus Sex Offender Registry Board. I remind everyone this is an impounded case, and so Doe's name and any other impounded material obviously shouldn't be referred to in open court. We will hear first from Attorney Hernandez.
Good morning. Thank you for hearing this case today. My name is Attorney Samata Hernandez, and I represent the plaintiff appellant John Doe. I'm here today requesting this court lower my client's classification level from a level 2 to a level 1, or remand the case back to the board for another classification hearing. I would first assert that the hearing examiner made an error by finding that my client sexually assaulted his wife in 2010. As you see in the record, there's no police report concerning this allegation. There's no charge. My client was never charged with it. And if you read the affidavits that are attached to the application for the abuse prevention order, the allegations are very vague. And also there's no witnesses. The allegations they're not detailed. There's just a flat-out allegation. There's no details in terms of the time frame, in terms of specifically what happened, where, none of that. So for these reasons, I would say the hearing examiner erred by finding that my client sexually assaulted his wife.
Wasn't there some corroboration by a third party, a pastor?
So in the police report, when the daughter reported the allegations, the wife was interviewed, and he indicated, or was it, one of them was either the pastor or the wife was interviewed, and they indicated the wife at one point went to him, that the wife at one point spoke to the pastor and spoke about possibly Doe sexually assaulting the daughter. And in passing, while she was talking to him about that, he indicated that something similar happened to her. Again, there's no details in terms of what, just sort of the word something similar happened to her.
But the pattern was pretty unique, right? So can't that be taken into consideration as to the reliability of this information?
So I think there just wasn't sufficient in terms of information, in terms of details in this. Again, there was no police report specifically with the wife's allegations. My client was never charged with this. And if you read again the affidavits, which is what the hearing examiner relied on, it's very vague in terms of what the wife was alleging. And I would argue that as a result of finding that my client sexually assaulted his wife, the hearing examiner erroneously applied 2 risk-elevating factors, and those are risk-elevating factor 21, diverse victim type, and risk-elevating factor 22, the number of victims. And I would argue that those 2 risk-elevating factors should not have been applied. In addition to that error, I would also argue that the hearing examiner should have given my client more weight for risk mitigating factor 33, which is home support and home situation and support system. Here, the hearing examiner gave it minimal weight, finding that my client was incarcerated during the time of the classification hearing. But that's unfair, in my opinion, because it was through no fault of my client's own that the hearing took place while he was incarcerated. So that's one point I would like to make. But in addition to that, the hearing examiner found that there was no home plan. But if you look at the record appendix, there's 2 letters, one from his father indicating that once my client is released from incarceration, he would be living at home with him.
No, it doesn't say that. It says
sorry?
the father doesn't say that the Doe would be living at home. The father says that he can live at home.
Yes,
I mean,
he
this
says-
is described as a release plan in your brief, but I looked at it, it doesn't look like a release plan at all. It looks like an offer, he has a place to live. That's not really the same as, and I plan to live there and work here and do, you know?
So and I understand what you're saying, but the purpose of risk mitigating factor 33 is if there's support from family and friends. And I would say that this is an element of support from family and friends, which is the father saying, he is welcome to live with me. There's no requirement that there actually be a home plan, but even that being said, this could be seen as a home plan because he indicated that he could live with him, he would assist him with finding a job and with a car. And then on top of that, there was a letter from his brother indicating that his brother would assist him with just sort of support in general. So I would say because of these two letters, and my client had no say in terms of when the hearing took place, that the hearing examiner should have given this at least threshold application. And then the other error would be the application of factor 16, the public place. I'm not saying this factor should not have been applied. I think it probably was appropriate to apply it under the circumstances, but it should have been given less weight because there seemed to be a deliberate attempt to hide his behavior.
You mean because in circumstances where everybody was asleep?
Yes. Yes, it was in the bedroom, everybody was asleep, and at the time at night that it took place. So I would argue that because of these reasons, he did make a deliberate attempt to hide it. Again, it should be applied. I'm not saying it shouldn't be, but it should be given less weight because of that.
Wasn't there someone else in the bedroom with the victim for many of the different nights, whether it was the friend for the night of the sleepover, the brother or the sister with whom she shared a room off and on over the years?
I think in the police report, there was indication that sometimes the brother was in the room. But with the hearing examiner's decision, that's not the reason why he applied this risk elevating factor. He applied it because of that one night that the friend was sleeping, I believe, on the floor that night. So, and I would say that just given the totality of the circumstances, by clear and convincing evidence, it wasn't sufficient here to find that my client poses a moderate risk of reoffending. He was close to 60 years old when the classification hearing took place. He was only convicted of one, heinous for sure, so I'm not going to take that away. But one index crime, which took place over a decade ago. He does have the love and support of his father and brother. He is a Navy veteran, and he is receiving benefits as a result of that. And while he was incarcerated, he had no D reports, and he was involved in institutional employment. So for these reasons, I would say that the board did not meet his burden of finding by clear and convincing evidence that my client poses a moderate risk of reoffending.
Can I ask one question?
Oh, sure.
Attorney Shai says in the brief that the only claims raised below were that the hearing examiner didn't take the release plan into account and the honorable discharge, and that public place shouldn't have been applied. Do you agree that those are the only preserved arguments?
Well, I would say that every argument I made regarding the factors, they were preserved. Because if you look on, let's see if I can find the page. Let's see. Volume 2, page 98. The attorney below did talk about that the hearing examiner made errors in weighing the factors. That was just a general claim. There wasn't any specific.
Was that in the brief, or that's a transcript?
That's in the brief, yes.
Okay.
Mm-hmm. So volume 2, page 98.
Yeah, I'll look.
And then, let's see, then there's another one regarding weighing of factors. It's volume 2, page 98. I'm sorry, I already said that. Volume 2, page 99. And then there's indication of public place on volume 2, page 101. An indication of the release plan on volume 2, page 100. So I would argue that all the claims were preserved. If there's no further questions, I'll rest on my brief.
I see none. Thank you very much.
Thank
Excellent
you.
argument. We will hear next from Attorney Shai.
Thank you. If it pleases the court, David Shai for the board. Looking at the evidence in this case, the board's position is that the level 2 was more than fair. I think there was some indications that it could have been a higher classification, but I think the hearing examiner did a good job of weighing out all the evidence to come up with a level 2. Based on the evidence of this case, based on his lack of real institutional programming, refusal to do sex offender treatment, and his lack of employment while incarcerated, I don't see how this would be reduced to a level 1 based on the facts of the case itself. So unless there's specific questions, I'd be more than happy to rest on my brief.
I wanted to ask a question about a phrase you use in your brief. You say that the examiner gave full mitigating weight to the petitioner's age. I tried to figure out what you based that on. You know, I think that it's undisputed that the examiner gave some sort of weight to the age, but the use of full mitigating made it sound like something really glamorous, glorious.
I think the hearing examiner wrote that they applied the factor, the reason I say that is because technically he hadn't reached the age of 60, where he would get, so theoretically his risk would be substantially lowered. The hearing examiner still applied the factor, and then when you read his discussion of the risk of reoffense, that's the main mitigating factor that the hearing examiner relies on in really reducing the level to a 2. So I think looking at the totality of the decision, I think you get to the point where you can say he did give full mitigating weight to that factor.
Okay, thank you.
I see no further questions. Thank you for your brief and brief argument. The brief is very helpful to us. That's all we've got.
Thank you.
The case is submitted. I'd like to thank the court staff for their assistance today and the court officer, as always, as well. We stand in recess.